y'all. Please raise your right hand, sir. Do you solemnly swear or affirm that the testimony you give to the court and the jury on the matter currently pending before the court will be true, the whole truth, but and nothing but the truth, so help you God, sir?
I do.
Please sit down. Take a seat, sir. Can you please state your first and last name for the court and the jury, please?
James Smith,
Can you spell your last name for the court?
S-M-I-T-H.
Okay. Mr. Smith, what do you do for a living, sir?
I'm an attorney at law.
Can you please speak up a little bit?
Yeah, I didn't know if I was too close to this or not. I'm an attorney at law, licensed to practice law. I have been licensed to practice since June of 1974.
So how many years have you been practicing law?
That makes 41.
41 years. Mr. Smith.
Or 1 year, 41 times.
Okay, Mr. Mr. Smith, do you know me, sir?
Yes.
Could you please tell the jury how you come to know me?
Well, you just reminded me that I had defended you on a charge and got you off of that charge. And then I defended you on the alleged, armed robbery, which you were subsequently convicted of. The pizza delivery guy, I think's what he was. I defended you in that case.
Okay, did I ever tell you I done that? What did I plead, guilty or not guilty?
Well, you entered a plea of not guilty, and your case was one of, your only defense was misidentification. If you want me to tell you the story of it, I can tell you what came out of the trial, basically.
Oh, did you please tell the jury?
Yeah, sure. Sure.
I don't think that's appropriate for him to basically provide what he says came out of the trial. Basically just talk about what happened.
Is your objection a narrative, or is it?
Well, it's a narrative. I think it's, transcript with that, in that regard, for him to basically just go into, launch into, I guess, a summary of what he says came out of the trial, that may be inappropriate, particularly if it may have opinions or otherwise.
I'm going to allow it.
Thank you.
What happened was someone down at Waterford Apartments at the foot of the hill here on Broad Street, where Oak Street takes off down the hill and goes across the river, someone had robbed a pizza delivery man. The police subsequently stopped the vehicle in which Jamie was riding and brought the pizza delivery man. He was stopped over here on West Broad Street. The police brought the pizza delivery man to the place where Jamie had been stopped. The pizza delivery man said that we have the suspect in your robbery here, and we want you to look at him and see if you can.
Excuse me, I think, did you say pizza delivery man, what the police told him up? I
Well,
think you misstated that.
well, not the pizza.
police-
Okay, the pizza delivery.
I think he can correct the witness. He's basically going to provide that.
Okay, I withdraw.
He already indicated that he had to remind him of that this morning.
Okay, well, the record here, Judge, I got the transcript here, so Ms. Maul want to cross-examine the record here. Let's just get, I'm sorry, Ben, if I'm just go ahead.
Okay, what happened was the pizza delivery man was brought by the police to the area where they had Jamie standing, and the police, according to the pizza delivery man, the police told the pizza delivery man that we have the suspect in your robbery. We need for you to see if you can identify him. Of course, the police in their testimony said they did not say that, but the pizza delivery man said that they told him, the pizza delivery man, we have the suspect, see if you can identify him. Well, quite naturally, they did identify him. And what happened in that case, that was his sole defense, is misidentification. Of course, there's a lot of research on misidentification, especially it was a white guy, especially when you have cross race and that sort of thing. Lots and lots of research on that. And if you want me to go forward, further, what happened was I had been talking with the DA. I personally had been talking with the DA 2 weeks or 3 weeks before this trial, and had informed the DA that we had an alibi witness, or witnesses actually, there were 3 of them, who could testify to where Jamie was during this period of time when the robbery occurred. They didn't get Jamie just within a minute or 2 after the robbery. It was a pretty good bit of time. And I had been talking with the DA who tried that case for at least 2 weeks about the alibi. They had the witness names and everything. And when we got to trial, I had simply passed my mind to file a written notice of alibi. The DA knew about the alibi. I had provided him with the names of the witnesses. The DA surprised me by objecting to the fact that I had not provided him a written notice of the alibi. That was Jamie's defense. There was one witness, identified him in the situation I just explained to you at night, shining with the lights shining on him in a police car, and the pizza man being told, we have the suspect, according to the pizza man. Now, his sole defense was his alibi. The judge ruled that because I did not give written notice, that we could not use that alibi. The case was granted a new trial, by the way, because of that, and retried, and there was another conviction. So, I mean, there clearly, in my opinion, was an incorrect ruling. In fact, I don't believe the judge. There's lots and lots of law that has to be bad faith and prejudice to the state. There's no bad faith on my part, because I was talking to the DA. He knew exactly what my defense was. It simply had not been typed out. So there was no bad faith involved in it, but the judge still, it wasn't this judge, by the way. The judge excluded the evidence of the alibi. And I strongly believe that that really affected the result of that case. And then because that case had already taken place when the new trial occurred for Jamie, it was a different story, because then everybody knew the routine. They knew how to try the case. The government did. The government knew how to try the case.
Mr. Smith, do you recall during that trial that you stated that y'all had a lineup schedule for the man to pick me out of the lineup, but he didn't show up? Do you recall that, sir?
Yes, I do recall that we had requested that, and it was supposed to be held. There was supposed to be a lineup, and I think the DA had agreed to it, if I'm not mistaken. The DA had agreed to just have a 6-person lineup and see if this pizza driver could identify him from that position. And that never happened, in spite of the fact that I did everything I could to have that lineup happen. And of course, that would have been after the one-man show-up, as we call it in the law. One man show up with the suggestive statement, we have the suspect. I still wanted to see if this guy could pick my client out in a lineup. That never happened.
So are you telling the jury that the man never showed up in a lineup that you asked him? Okay. Did he fail to show up to the lineup that y'all had scheduled? And we was all waiting on Sunday, and he never showed up?
That's correct.
Do you recall making a motion for a direct verdict to the judge?
Well, of course.
According to this illegal identification, sir?
Of course, and it should have been a mistrial or a directed verdict or a continuance, or a lot of things that should have happened, especially where there was no bad faith on my part. It should have been just a break in the trial long enough for the DA to investigate whatever needed to be done. But because we were denied the opportunity to submit the only witness, 3 witnesses, the only 3 witnesses who could have rebutted, the only witness who identified Jamie. We were not allowed to present that evidence. And even though the DA was fully aware of what my defense was. And
Your Honor, may I have him review a portion of the transcript and just refresh his memory on the time?
Can you mark that?
You want to mark? Which one to mark the whole transcript, intending the whole entire transcript? Should it?
So if you're only gonna do a couple of pages, you could cite what pages they are, and mark just those,
Okay.
those 2 or 3 or whatever it is. Okay. This would be number 88. Okay.
Your Honor, I would like to, it's page 338 to 342, the first trial transcript, Your Honor. Well, we got 338, 342. Okay. Let's stick it. You said this would be number 88?
Yes.
And while we at it, I'd like to introduce page 264 also. That'd be 89.
Yes.
I would also like to make a request to introduce number 90, page 111 through 114.
I would like to reflect, since it has the pages, this is, transcript of the first trial of Jamie Hood in that case number. That was held December 15, 16, 17, 1997. First trial that he had, which he was convicted right here. These are the pages that I included to come to that particular transcript.
Your Honor, also page, I'd like to introduce defendant, exhibit 91, pages 140, 141, sir.
140 and 141.
Yes, sir. Smith, are you finished with any of those? 88, whatever you finished with, may I have what you finished with, please, sir?
Okay, I've familiarized myself with 88.
Okay.
Okay, I'm familiar with 89. Number 90, reviewed.
representation, what you remember that trial?
Yes.
So you recall what you seen in the defendant's 88, 89, 90, 91, sir?
Yes, basically, yes.
Okay, is it a fair representation what you remember that trial?
Yes.
Your Honor, I would like to tender evidence, defendant 88, 89, 90, 91, sir.
Any objection?
No, sir.
Okay, that's noted. All right. Mr. Smith, I'd like you to look at the defendants. Exhibit 91. Page 140, 141, sir.
Okay.
Okay. Did we have a little later? You have
I could
one?
probably mark, I can't know.
Okay, I see. I'll leave them. Okay, thanks. Ms. Smith,
Show what page that is.
okay, it's page 140, page 140. Mr. Smith, after reviewing page 140, do this talk about the identification that the guy missed? That was
Yes.
scheduled when he had missed, sir? Do you
Yes.
recall that?
Yes.
Okay, did he say anything, do you recall him saying anything about he missed it because he had to be in Washington? Into this, you see that anywhere here with family and friends, line 15 to 16? line
Yes.
15?
Yes.
So he stated that he missed identification because
That's
he,
all we.
okay, but did he state that he missed identification because he was in Washington DC, fair to get back?
Yes, yes. Even though we had planned on it and expected it, and we were not informed that he would not be there.
So you didn't have no idea that this guy was gonna miss the identification that you had set up?
We had it set up, no reason to believe he would not be there.
Okay, because you said the jury why it's important to have a correct lineup.
Well, actually, you have introduced some of the evidence as to why the police officer testified about the possibility of misidentification. It's certainly enhanced greatly by the police response to one of the exhibits that he just introduced. Was he walked up and said, "Is that the suspect in the armed robbery?" And they said yes. That's in the transcript of what occurred between the police officer and the pizza guy. And not only do you have one person show up at night with a police answering, yes, that's the suspect, that is a suspect. You have the cross-racial identification problems. You have the fact that identification is so unreliable. Eyewitness identification is so unreliable that there should have been other efforts made to corroborate the identification other than this alleged one few minutes robbery of a pizza guy. I mean, and that was the identification. And there's so many, the police officers testified in the transcript that he's introduced, the police officers testified about why show-ups are not, and why show-ups are not necessarily favored, and why the officer should never tell, in a show-up in particular, that we have the suspect out here, we want to see if you can identify if he's the robber or not. And the police officer testified to that at that trial.
Mr. Smith, I would like to direct your attention to exhibit 89, page 264 for the prosecution. Page 264, sir.
Yes, sir.
I'd like you to look at, do you recall you talking to the police about why it is important not to tell a victim or a latest victim that you have a suspect right here? Do you recall having this conversation at trial?
Yes, well, you can see on line 4.
Line 4.
You-
Okay.
What happened was they had stopped a Honda. Apparently there was a be on the lookout Bolo for some kind of vehicle. They stopped this vehicle that Jamie was in, you were in, and the officer, the pizza driver walked up to the officer and said, "Is that the suspect in the robbery?" The officer said, "I told him," it says right here on line 4, line 5. In line 5, it says, the question was, walked up and asked if that was suspect, and you said, "I don't know." Answer on line 7, that's correct. Line 8, well, now, which is true? You stopped him because they might be suspects, or you didn't know? Answer, I told him I didn't know because I did not want to lead him onto the fact that they might be suspects and have his falsely identify them as a suspect. Question, line 13, me. That certainly would be a tremendous factor in identifying falsely if you suggest to the person that we've got the suspect, wouldn't it? Line 16, answer, yes. I mean, if I told him we got the suspect. Question, that would tend to lead someone to make a misidentification, wouldn't it? Answer, that could, yes. Question, that's an important thing, not to let the person know you've got a suspect, isn't it? Answer, it's important in the way that you present yourself to somebody. That's the officer's testimony.
That was the officer's testimony.
That's correct.
Okay. I'd like you to look at defendant exhibit 90 from page 111 through 114. I'd like you to start at 111, page, well, I guess you can start at the top.
Can you line it up on,
Okay, I'm sorry.
where do you want me to start?
You can start at the top. Let's say this 5, I guess you can start off.
Okay, question, what happened then? Answer, I told her that somebody's, over there in that area, and then the other one went by, and then she said, they're looking for him, and then she hung up with me and said an officer would be there, and a couple of minutes later, an officer knocked on the door. Question, did you in fact speak to an officer that night? Answer, yes, sir. Question, did you give him some information that night? Answer, yes, sir. Question, what kind of shape were you in when they were talking to the officers? Answer, I was a little shaken, a little upset, really scared. Question, what did you do after you finished talking to the officer? Answer, I filled out some paperwork and they released me and told me to go, and then when I left the parking lot, I made a right and went down in the general area where he ran off to, just to see if I saw him running out or something like that. But I didn't see anything, so I made a left onto Broad Street and went. Question, now again, just to get this in our minds, this is, by the way, answer, okay, Mr. Love, if he could step down for just a minute, Your Honor. This is the DA's examination. The court, yeah. Question, now after you left the apartments, Waterford Apartments, which way did you go? Answer, I left there and went out this way in the direction that he ran, and I came up this way to Broad Street, and I was going back to Papa John's. Question, now where is, if you'd like to sit back down. Question, where is Papa John's? Answer, it's on Baxter Street. Question, so which way did you drive to go back to Papa John's? Answer, I was going to go down Broad Street to around where Vision Video is. I don't know if everyone knows where that is. Question, is that your normal route to go back there? Answer, it varies. It depends on where I'm coming from. If I'm coming from the downtown area, I probably go that way. If I'm coming from campus, I'll go Baxter. Question, now Vision Video, is that a shortcut if you cut back through there? Answer, yes sir, one of those side streets.
113.
Question, so did you remain on Broad Street as soon as you got off of Wilkerson Street then? Yes sir. Question, and as you drove up Broad, did you notice anything? Answer, yes sir, maybe at the intersection where the Marriott is. I'm not sure of the name of the road. I noticed a car stopped and there was a lot of police cars surrounding it. Question, what did you do at that time? Answer, so I stopped to see if maybe it was the man who just robbed me or maybe a suspect in it. So I stopped on down the road, and so no one could see me or anything like that. Question, how far did you stop away from where they had stopped that man? Answer, about 50 yards. Question, now did you see anybody outside of the car that night? Answer, no sir. Question, could you see police officers? Answer, yes sir. Question, did you see anyone else outside the vehicle? Answer, no sir. Question, what was the first thing you said to a police officer when you walked up? Answer, well, I walked down the street and I came up and I was trying to stay behind a car, so I just didn't want to be seen by anyone. I asked him if by any chance that the people inside the car were a suspect in the robbery that just happened. Question, and what did the officer tell you? Answer, he told me yes. And he asked me why was I asking. And I told him that I had just been robbed. Question, what happened then? Answer, he told me just to wait there behind the car. Question, do you know which officer you spoke to? Answer, no, sir. Question, what happened after that? Answer, I waited there for a while, and I believe it was a sergeant who came up. It was the head policeman. I guess it's the sergeant. Question, why do you think it was a sergeant or somebody different? He had a different hat, and when he showed up, a lot of the police officers hopped in their car and took off. So I guess, question, you thought he was the boss then because, answer, yeah, he seemed to be the boss there at that point. Question, what happened at that point? Answer, I see the officer who I spoke to talk to him, and then the sergeant came and talked to me, and he told me that I
ain't trying to read the whole transcript, so I just want to make a valid point. Well, I'm not finished. Ask the question. Mr. Smith, I'd like you to look at Defendant Exhibit 88, pages 338 through 342, sir. I'd like you to start at number 9. Do you recall that's you, Mr. Smith? Is that you?
Yes, that's me, and that's where I made the motion for the directed verdict. And I also pointed out.
Could you read?
Sure. I'd like to make a motion for directed verdict, and I'd also like to renew at this moment my previous motion to exclude the identification testimony. Now, it did not come out at our preliminary pretrial hearing that the alleged victim was told that the suspect of the robbery was standing there in the police glaring headlights. And now we have learned through the trial that when Mr. McKeon drove up, the first thing he did was say, are these the suspects in the armed robbery? And the answer was yes, or yes they were, or yes they are the suspects, whichever way you want to say that. All the witnesses have testified that that is very suggestive it would be improper to say that. The alleged victim himself has unequivocally, and I crossed him on that point, indicated that that is exactly what happened. In fact, he testified during direct examination. Yes, they were suspects, is what the officer said. And I jumped on that. I'm talking about myself. And he said no. I asked him if they were suspects, and the answer was yes. And then they took my client, stood in for 5 minutes at least in the doorway of the police car, took the photograph which has been identified and introduced and allowed into evidence, and the state's exhibit number 22. The alleged victim making the observation throughout the entire time if there could possibly ever be a suggestive identification process where there's a show-up, that's it. Now the victim has now come into court and told all these different stories, it's talking about other parts of his testimony, that were never told to any police officer or anybody else prior to just getting ready for trial, about seeing somebody walking down on Coney Street, seeing that person walk up to him with the face unconcealed and then seeing the runaway. All of that is new evidence. He was obviously attempting to bolster his identification testimony. Your Honor, none of that evidence existed as far as the police. He didn't tell anybody about all that. I suggest that all of that is fabrication now to make up a problem the state would have based on his testimony that they told him that the suspect was here. And I would like to renew my motion to exclude that in-court identification, which was, I think, staged to say the least by this victim.
Number 40, please, sir. 340.
You want me to read what Mr. Luck, the DA, said?
Oh. I didn't keep showing everything. We're going to show everything. Go ahead, read.
Mr. Love, who is the DA? He's the assistant DA who was handling the case. Your Honor, of course, this is a totality of the circumstances test. The victim stated from the stand that this is the man that robbed him. The reason I remember that is because I saw him when he robbed me. That's all that is required. There has never been any evidence in here that this man was led by the police to pick out this man. This isn't a show-up. He keeps hearing it. I could object every time that this is said. This wasn't a show-up. He had 2 men out there, similar-looking men, and he picked out this man immediately when he's up there. This is very simple. Mr. Smith has arguments for the jury. This is for the jury to determine. This is not for this court to grant a directed verdict at this time. There is evidence, if the jury believes the evidence that they have heard in this case, where they can find Mr. Hood guilty beyond a reasonable doubt, and that is the standard to show a directed verdict. Not that some of the evidence may be contradictory, and not that some of it may be questionable. Not that Mr. Smith can ask good cross-examination questions. None of that is a standard for a directed verdict. It's whatever is there, sufficient evidence. It's whether is there sufficient evidence for this jury to find this man guilty beyond a reasonable doubt, and there is, certainly is. So we'd ask that the court overrule that motion.
341, please. This is Mrs. Smith. Is this you?
Yes.
Okay, could you please lead on? Line 1.
I renewed my motion to exclude the identification testimony. The court, okay, you're not making a motion for a directed verdict? That's me. Now that's a second. The court, well, go ahead and tell me. I thought you had, but go ahead and address that. Mr. Smith, well, I'd like to also make a motion for a directed verdict of acquittal because the identification testimony of the in-court identification is so tainted that it denies my client due process for him to be identified out there on the street by police officers as the suspect. My client stands there for 5 minutes at least. And if you, Hill Steve, testified it was about 40 minutes my client was out there with this alleged victim. And I think that is so suggestive, with my client being the centerpiece. There's a tall guy and a short guy. My client is short. You can tell from looking at the photographs taken out there on the scene by the police, as they've got them both standing at the same place in front of a door, a business door, and it's so suggestive that the in-court identification of my client, I think, is tainted beyond cure. We attempted to do a lineup. This alleged victim refused to participate. I think it's obvious that he knew there was a lineup set up for 7 o'clock Sunday evening. He intentionally did not try to get back in time to do that lineup. And that, I think, goes also to the credibility of the fact of the in-court identification, and it was so suggestive that I think due process has been denied my client from the in-court identification. He did ask that my client be allowed to sit in the audience. We did ask that my client be allowed to sit in the audience with at least 4 or 5 black males sitting in the audience. And we asked that he be allowed to sit out there. I realize that's probably discretionary, but I've done everything I could to try to make sure my client wasn't the only black male sitting in front of the rail at a table. And that's what happened. And I think it's so impermissibly suggestive that it denied due process. If you eliminate the in-court identification, there is no other identification of my client that would, and I would like to make a motion for a directed verdict of acquittal on the alternative that the in-court identification be stricken from the jury's consideration. The court said, all right, thank you, Mr. Smith. At this time, the court's going to deny your motion to exclude the identification, in-court identification, and the motion for directed verdict.
Mr. Smith, would you please tell the jury what due process is for identification?
That would not be permissible for us to basically start citing law or have him go into that law. That's not proper for witness. Law comes to court.
Yeah, I want them to know what's going on. You know, if he can't explain the law, the due process, he just stated due process of law, or could he explain to the jury why he made his motion? Because ultimately led me to go into prison. He saw what was going on, and I want the jury to see what happened.
I'm going to sustain the objection to the question that you asked. You can ask another question.
Okay. Mr. Smith, why did you make that motion for a directed verdict?
Because your sole defense was that you were misidentified by the victim.
Mr. Smith, did I ever tell you I done that?
No, of course not.
Did I always tell y'all incident and talk? Always?
Yes.
Okay. And I received a new trial because the judge said you was ineffective because you didn't call my alibi witness. Is that correct?
Yeah, he said I was ineffective because Mr. Love got up at the trial and said I had not given him written notice of the alibi. When we'd been talking about the alibi for 2 weeks, who the witnesses were, that was all I've already testified about that. He knew all of that, and then for the blindsided me in saying that you didn't put it in writing. And the judge denied, even though that was his sole defense, that he was misidentified, the judge denied the alibi witnesses' ability to testify with me. And then granted another trial. And in my opinion, that was error on the judge's part. In fact, there's been a lot of recent law. I've got one of the cases in my hand that were...
He can't go
And I'm not,
What he says is recent law and his opinion about that, that's not right.
well,
What, young?
I just think the judge was wrong.
Okay. You didn't agree what the judge did, did you?
Well, you know, they are subject to review by appellate court, so yes, I don't think the judge was correct.
Okay. Well, young, I would like to introduce the defendant, exhibit number 92, page 405, and 406 at this time, please, sir.
Is that the same transcript?
Yes, sir, yes, sir. Thanks, thank you.
Yes, I see this. It's sort of out of context, I'm not sure. I'm not exactly sure of the context.
Mr. Smith, do you recognize what you read in defendant's 92, in trial number 1?
I think that's, I don't really recognize that. I know that the manager of the hotel where Jamie had either spent the night or was spending the night.
Oh, excuse me, I think you're going too fast. I'm trying to introduce you. Do you recall, am I going too fast? Are you going too fast?
No.
Oh, yeah, okay.
You just,
I'm just trying to outline, I do recall that the manager of the hotel testified.
Okay, so you recall yourself in this transcript which you just read?
Yes.
Okay. Your Honor, I'd like to introduce defendant exhibit 92, page 405, 406, consider out of transcript number 1.
Okay.
Ms. Smith, I would like for you to look at defendant's 92, page 40506. I'd like for you to start at number 10 here. I'm sorry. Number 10, where you see yourself, can you start at number 10? Right here, number 10, and read on down.
Yes, sir. I say, Your Honor of the court. Yes, sir. Yes, sir. Me. I think the state has a duty not to put up testimony that it knows is false. I think they're fixing to put up testimony that they know from having contacted people at the hospital is false. The court, well, what I'm required to do is ask Mr. Love point blank, are you putting up testimony that you know not to be true and putting up any person that would be perjuring themselves under oath in the next set of witnesses you've got, Mr. Love? Not unless he told Mr. Smith something that I don't know anything about. Now, I don't know what he may have told Mr. Smith, but the testimony I've got, I'll give you a proffer of what I was going to ask him. He said that sometime between 11:30 and 11:45 that there was a phone call made from that room, and that Mr. Hood was staying, from that room that Mr. Hood was staying in, that the rent had not been paid that day, and so he went to check. There was a female in there by herself. It was no later than 11:45 when he got there to that room. The court, Mr. Smith, Mr. Love, I don't know if, Mr. Smith, let's listen. Bring the jury out and let me listen to him. The court, all right, bring the jury out. Royce Gunter is the name of the manager of that particular, was, he's deceased.
Okay, he's deceased. Now, Mr. Smith, what I'm gonna try to do is question him, so I'm about to introduce all this, but if I have to, I have to. Mr. Smith, why did you state that you thought that possibly you finna present false testimony against me?
I don't remember.
You don't
I
remember?
wish I did, I don't remember that.
Well, you know, I have to introduce,
If you could just let me refresh my memory on something, I'll be glad to read it, and then I
you
can.
wanna refresh it or play it, just don't introduce?
Proceed the way you,
Okay.
I'll do that. But,
Yeah, I just normally do it so they can see it. I tried. I'd like to introduce exhibit, oh yeah, 93, we can get to 92. I'd like to introduce defendant exhibit number 93, pages 407 to 415. Yeah, I ain't gonna do it like that. I just scratch that. I think they kind of go down.
If I could,
I just withdraw it.
if you'd let me, Jamie, if you'd let me look at it, I can maybe answer your question.
Okay, I'll let him look at it, because there's a lot to read here. So I just let him look at it, then he can answer questions what he got.
remember the exact time frame, but what happened was, the manager of the hotel,
I don't think you can just start going into stuff. It has to do with
Yeah, I'm sorry.
questions and everything.
I just was drawing.
oh, I thought he had asked.
I just sorted up. Ms. Miller, based on the thing that you just read, is that's why you make that statement that they put up false testimony?
Yes, but, yes, and I can explain that.
I mean,
I-
they ain't gonna let you explain it.
No, I have a right to explain it.
Okay, go.
I think I have a right
Have
to.
that exchange between the witness and the person asking the question.
Well, I would ask for permission to explain mine. Thank you, Your Honor. What happened was, there was a time problem with the state's case, and the alibi, of course, would have contradicted the state's time frame. The state put up Mr. Royce to prove that the alibi would have been false, but the problem was, unbeknownst to them and to the state, actually, the lady, Royce testified that he went into that room before 11:30, which that's the important time in this case, that case. Unbeknownst to them, however, the lady who was in that hotel room, he said it was before 11:30, the lady in that hotel room did not check out at St. Mary's, at Athens Regional Hospital, where she was working, until 11:30. Her time clock, we had the time clock showing that she checked out at 11:30, which directly contradicted the time frame of when the pizza guy was robbed. And that's why all that became important.
Well, Mr. Smith, I have no further questions, Your Honor, because I raised that issue.
Okay, well, let's see.
Yes, I do have questions. We'll take a very short recess.
Okay, we'll take a short recess, unless the jury goes to